అయ్యప్ప appellant. అయ్యప్ప okay, appellant.
Remember, the last occasion, I completed a list of synopsis and what? List of enactments. Dated 16 to 24, filed before this court, last occasion. Have got it? To refresh my memory, my lord, I was explained to this court article 233 to 236. Copy the idea. For the convenience of the court, brief notes separately given, my lord. Memo of enactment site, my lord, is separately given. My lord may take the memo of enactment which I have produced on the same day, both. Yes, my lord, dated 16/12, filed before this court, last occasion. My lord may take the memo which contains as many as Lord 16 documents. Lord got it. But I was explained to this court, Lord, Article 233, 34 and 36 expression of the chief judge. Then when quota commenced in 62, recruitment only to the post of district judges, Lord, promulgated by the governor under 309 of the Constitution. There also, Lord, 1/3, 2/3 quota. 27/883, Lord, also, Lord, 2/3, 1/3 quota. I was explained to this court, Lord, super time scale was created in the 83 rules. There are two categories of district judge entry level, district judge, Lord, super time scale. My lord got it, page 5. I will not trouble your lordship, my lord. Why? Because rule 2, Lord, indicates, Lord, district judge super time scale, district judges. My lord got it. Lord, you will find district judge super time scale is only by way of promotion by selection from the cadre of district judges by the High Court of Karnataka, must have put at least 5 years. Only way is promotion, only 5 years, super time scale. That is fixed by Supreme Court in 2002 Supreme Court. The first time Supreme Court accepted, Lord, the Justice Shetty's commission, where, Lord, commission, Lord, says percentage should be fixed to the selection grade district judge as well as super time scale. I will not come to the GO later. Now, my Lord, page 5, I will not narrate again. Lord, rule 3, application of other rules also I have already narrated, my Lord. Probably page 7. Page 7, rule 3, application of other rules. All the rules, Lord, promulgated by, Lord, under any law or under Article 309 would be applicable to the cadre of district judge. But general recruitment is concerned, Lord, all are not applicable. only certain provisions of general recruitment rules will be applicable. 77. Clause 3(1), my lord will remember, my lord kindly note, subject to Article 233, 33, 34, 35. Only, my lord, 5, 6, 2, 6, 3, 8, 9, 10 to 13 of general recruitment rules will be applicable. Not all. But clause 2 says all other rules. My lord may ask me what are the other rules applicable? Myself, I will ask you a question. Other rules are, my lord, Karnataka Government Seniority Rules 1957, Karnataka KCS Probation Rules, my lord, KCS Conduct Rules. All these rules are applicable. New, my lord, this rule is a repeal. In 2005, page, my lord will kindly note the date. Quota, my lord particularly asked the question, when quota applies. Quota is applicable. Why, my lord, I am telling it from, my lord, 20, my lord, my lord, 1983, rules were promulgated, fixing the quota 1/3, not 2/3, to the post of district judge, entry level. Not that rule, 83 rule. I will not read again. Lord, page 16 is the 2005 rules. All India Judges Case Lord 2002 Supreme Court. After accepting the Lord Justice Shetty's commission pay commission report, this is the quota fixed. 24/8/1983 till my lord 9/9/2005, 2/3, 1/3 quota is applicable. It is admitted by the High Court also in the earlier litigation and before this court also. Though my lord, other appellants have taken a different contention, there was no quota till 2005. But High Court admits, my lord, 83 rule is applicable. 2002 no. 2005 not 2000. Sorry. The reported judgment order 18 2005. Reported judgment order.
2011 ಅದು
ಅದರೆ 2002 ರಿಪೋರ್ಟ್ ಆಯ್ತು.
2002
ಈ ಬಂಡಲ್ ಮುಗಿಸ್ಬಿಡುವ.
ಇದರಲ್ಲಿ ಕೋಟಾ ಬಿಟ್ಟು ಮತ್ತೆ ಇದು ಚೇಂಜ್ ಆಗ್ತಿಲ್ಲ. 50% ಪ್ರಮೋಷನ್ 25%. ಕೋಟ ಇಂತ
ಇಲ್ಲ
ಚೇಂಜ್ ಇಲ್ಲ,
ಡೈರೆಕ್ಟ್ ರಿಕ್ರೂಟ್ಮೆಂಟ್ ಚೇಂಜ್ ಇಲ್ಲ.
50, 25, 25.
But as far as 2005 rule is concerned, Direct recruitment concern, no change in quota. Only, my lord, the direct recruitment concern, my lord, 25%. Kindly note it. 83 rules, my lord, 1/3. That change is seen now here, 25%. Then what promotion is concerned, my lord, 50%. Promotion by competitive examination is concerned, my lord, 25%. How, my lord, Supreme Court legislated the law. 50%, Supreme Court said, but 50% is concerned, Lord, merit come seniority. But however, recruitment rule says, Lord, seniority come merit. Kindly note it, the Supreme Court judgment and the rule. 50% as per the rule is, Lord, seniority come merit. As the Supreme Court judgment is, Lord, merit come seniority. Only distinction is that 50%, 25%, 20%. Direct recruitment is concerned, Lord, 25%. Rather than what? 1/3 percentage of what? Old rule of 1983. My lord, this rule also, my lord, particularly, my lord, application of other rules. Kindly take page 18, rule 11. Rule 11. My lord, there is no difference of application of, my lord, other rules as enumerated in 83 rules. Kindly see, my lord, the rule 11 clause 1 says ditto, no change. General recruitment is concerned, those are the provisions applicable to the district judge and other Lord civil judge, Lord junior division and senior division. 2 is, Lord, same as it was 83 rules. All other rules, no change. Then, my lord, kindly see page 19. Repealing of 83 rules, my lord. Lord, 83 rule is repealed in, my lord, by recruitment rules of, my lord, 2004, which is gazetted on, Lord, 9/9/2005. But I am again saying, my lord, provisions of 1978 Act is not applicable. But all rules promulgated under 1978 rules are applicable because 11.2 says so. 11.1, 11.2 says so. All rules, Lord, how it is worded, Lord, 11.2 is, Lord, all rules regulating condition of service of members of a state civil services made from time to time under any law. What is any law? Any law is, Lord, provisions promulgated under 1978 Act. Because Karnataka is concerned, all rules pertaining to recruitment shall be promulgated, Lord, provisions of the 1978 Karnataka Civil Service Act 1978. But to promulgate rules pertaining to judicial department, Lord, 78 Act is not. Though preamble says so, it is 233/34, Lord, enable the governor to promulgate regulation rules. So provisions made under other law means 78 rules made under 78 Act is applicable. Now, my lord, page 20. But this is All India Judges Case, my lord, 2010 SEC. This, my lord, rule was promulgated, changing the quota. But what is the change, my lord, of the quota is, my lord? This is applicable to our recruitment rules because we are appointed during the year 2016. My lord, may kindly see, this rule is promulgated on 11/7/2011. But quota operates, this quota will operate, Lord, from 11/1/2011. Kindly note the date. Those rules were promulgated on 11/7/2011. Rules comes into effect, my lord, on 1/1/2011. My lord may ask me why 1/1/2011. Myself, I will ask you that question. My lord, Supreme Court says before 1/1/2011, if the law is amended, this order will prevail. 2010 Supreme Court says, if the all high courts do not promulgate the rule as per the judgment of 2010, law made by the apex court will prevail on 1/1/2011. Exactly. Now, my lord, I will point out that, my lord, on the 2010 Supreme, my lord, itself, absolutely no difficulty.
Citation will go into those.
10. ಕೊಟ್ರಾ ಸರ್? ಯಾವ ಕೊಟ್ರು citation? ನಮ್ದು ಕೊಟ್ರಾ? 2010.
ಮಂಜು 61.
Not page 61. 61 ಅಲ್ಲ, 61 ಅಲ್ಲ. 2010. 53.
Court officer. 53.
Page 53 ಮೇಡಮ್.
The judgment, the submission of the other side is amendment is required. Court officer.
My lord, I will not read the entire case law. But other side argument is, unless the law is promulgated by the respective state, law will not come into effect. That is what the made submission. If my memory is correct. Kindly take para 8. Para 8 of the judgment, which answers that when rules will come into effect.
Page 56.
Page 56 only, para 8. I read that paragraph only, my lord. Page 56, my lord, got it? ಎಲ್ಲಿ?
ಇದು
ಅದು ಕರೆಕ್ಷನ್ಗೆ
ಇದೆಲ್ಲ
ಅದಲ್ಲ 2010 ಮಿನಾಟ್ ಪೇಜ್ 53. Maybe, yes. Para 8, page 56, para 8. Well, that is right. But I'm making my submission that this is not a correct submission made by the counsel for appearance in other appeal, not by High Court. Not by High Court. Para 8. Hereinafter, there shall be 25% seats for the direct recruitment. Not from the bar, 65 seats are to be filled up by regular promotion, civil judge senior division. 10% seats are to be filled up by limited departmental competitive examination. If candidates are not available for 10 seats, are not able to qualify in the examination, then vacant posts are to be filled up by regular promotion in accordance to service rules applicable. Para 9. All high courts are hereby directed, kindly note it, to take steps to see that existing rules to be amended positively with effect from 1/1/2011. If the rules are not suitably amended, this order shall prevail. Kindly note it. Further, recruitment from 1/1/2011 shall be continued accordingly as directed by us. Therefore,
Amendment is not at all necessary.
amendment is not at all necessary. It is not a correct submission made before this court. No, my lord. Yes, my lord. But they say 1/1/2011, my lord. Kindly note it, my lord, page 20.
Date of the order
Date of the order
होवे
is
24 2010.
my lord, 20th April 2010, my lord. Date of the order is 20th April 2010, my lord. 20th April 2010. ಅದಕ್ಕೆ ಅವರು ಏನ್ ಮಾಡಿದ್ರು ಆ ವರ್ಷ ಎಂಡ್ ಆಗಿದೆ ದಟ್ ಇಯರ್ ಶುಡ್ ಎಂಡ್ ಇಟ್ ಶಲ್ ಕಮ್ ಇನ್ ಟು ಇಫೆಕ್ಟ್ 1/1/2011 ಅಂತ ಹೇಳಿ. But kindly note it, not page 20. My lord, kindly take amendment to rule 4. My lord, got it, my lord? Kindly see, my lord, the substitution. Serial number 1, figures words 50% ittu yavaga. My lord, 2005 rules says 50% shall be filled up by seniority cum merit. Is substituted, my lord, 65 of the total post shall be deemed to have substituted with effect from 1/1/2011. Why the date appeared in the recruitment rule is, Supreme Court says if you don't amend, whether you amend or not, this order will come into force from 1/1/2011. That's all substance. Lord, no change, my lord. Subsequently, quota is concerned till 25. I'll come to the judgment. Later judgment is again, my lord, restored to old quota. That, my lord, may not be necessary, but I'll point out the judgment. I'll give it to your lordship, lord, that judgment also. This is now reversed recently, very recently. My lord, the page 22, some amendment is there, my lord. It is
Promotion has taken place.
because promotion and, my lord, and direct recruitment took place. This page 20 rules is applicable during that time where we are recruited. Promotion, same rules will be applicable. Promotion and recruitment is concerned, 25% remain, my lord. Only promotion is concerned from 50 to 65. 10%, my lord, competitive examination. Only change is that much. That much. Lord, page 22, my lord, only the High Court adopted the physical handicap reservation. That is there in rule 9 of the general recruitment rules. It is adopted by the High Court. The rules is promulgated. 15 amendment is made.
However, this amendment in tune with the general recruitment.
Lord, page 22, 2015, Lord, in tune with rule 9 of the general recruitment rules, Lord, they promulgated the rules. Reservation for disabled person. Disabled person. Lord, page 24, Lord, circular, the official amendment dated 5th July 2076, Lord, is the state of Karnataka issued circular pursuant to the judgment of the Honorable Supreme Court in V.B. Badami of the state of Mysore. Supreme Court says in V.B. Badami state of Mysore, Lord, quota is applicable from the date of rules which comes into effect. Nobody should breach the quota, either direct recruitees or promotees. My lord was asking the question, when quota, why quota 83 or 62? But 62 is concerned, quota need not be operated. Why? Because there is no dispute at all. Only dispute arose is, my lord, 2012, when 83 rule was in existence. This court has quashed the seniority rules. That was the first seniority list quashed by this court. there was no seniority list attained finality. Then, my lord, appeal 2014 division bench, my lord, also modified that order. Though it has upheld the, my lord, quashing, it modified certain directions are issued. No seniority district judge is finalized. I am saying, my lord, 27/8, my lord, 83 quota would be applicable. 1/3, 2/3 till 2005 rule is promulgated. From 2005, my lord, onwards till, my lord, 31, my lord, 12, 2010, same quota, my lord, is applicable. Then, my lord, 1/1/2009 onwards, my lord, 65 promotees, 10, my lord, is the competitive exam. Direct recruitment, 25% remains. That means, my lord, 2004 rules onwards, 25% quota remained unaltered as per direct recruitment is concerned. This is, my lord, on the face of the rule I am making my submission, not anything else. No interpretation is required for this, according to me. My lord, 76 circular I have produced because to show that from the rate of promulgation of the rules prescribing quota, my lord, seniority list has to be prepared. In this case, my lord, 27/8/83 onwards, because there was no dispute prior to that seniority is concerned. First time dispute was in 2012. On facts, my lord, I will come later. I will just finish this, my lord, the enactments. Then, my lord, I will come to facts directly. Nobody can encroach the quota, either direct recruits or promotees, or, my lord, promotees under the, my lord, their quota, 10% quota, whatever. That is the, my lord, ruling of Supreme Court. It says only vacancy, but as far as judicial district judges is concerned, post-based classification. That, my lord, I made it very clear. Badami says vacancy based, but the rule says here post-based classification. Not after Sabruval. The recruitment rule itself says here in Karnataka. Judicial judge recruitment rules. 83 says, 83 rule says Sabruval prakara amele post based madidare Karnatakaದಲ್ಲಿ. But our recruitment rules, my lord, I must make a fair submission. But 83 rules also says post only, my lord. Civil service is concerned, my lord. KAS is concerned vacancy based, my lord. KAS and other service is concerned vacancy based. But that KAS vacancy based was also changed in 94. Vacancy is concerned, it is removed. Recruitment is amended. Then more interpretation came before the division bench of this court. This court said, though VV Badami is curtained to KAS junior scale blood seniority, since the 94 recruitment is silent about vacancy, post-based classification is applicable. And this court held long, about a year back. Now, my lord, coming to the, my lord, the page 27, my lord. My lord, official memo is used to maintain the vacancy register. That is not, may not be much, my lord. It's not necessary. Page 31 is, my lord. Page 31, my lord, 14/12/87 is the, my lord, principle laid down by the Honorable Supreme Court in Gonal Bimappa. Badami principle is reiterated by Supreme Court in Gonal Bimappa. That is all the difference. Again, official memorandum by DPR is issued. Yes, same principles. Supreme Court, my lord, reiterated Badami would apply. That's all, my lord. Next, my lord, the very important is the, my lord, page 36. My lord, now ask me a question myself. But I made a submission before your lordship, my lord. super time scale selection grade is created by Supreme Court. My lord, accepting Lord Justice Shetty Commission report in 2002 with effect from my lord 1 my lord 1796 1796 in 2002. My lord, Shetty's Justice Shetty's commission pay commission report is accepted. My lord, selection grade post is created. Percentage is fixed from all level. Earlier, my lord, in 83 rules, my lord, will find the super time scale only by promotion, but district judge entry level. But now, my lord, scene is entirely different. Kindly see, my lord, this reference, page 36. Lord, got it? Judgment of the Honorable Supreme Court dated 21/3/2002. All India Judges Association was Union of India. Order of the Honorable Supreme Court on 6/12/2005, 7/2/2006. All India Judges Association versus Union of India. Then, my lord, letter dated received from the Registrar General High Court of Karnataka. Kindly noted, my lord. Letter dated received from the Registrar General High Court of Karnataka. Referring to this, my lord, the quota is fixed from district judge level, entry level to selection grade and super time scale. But I will not read the entire GO. I will draw your lordship's attention. District judge entry level, they must deduct, my lord, 35%. 35%. Kindly take, my lord, page 39. Roman 2. My lord, got it? Why am I emphasizing this, my lord? Kindly note it, my lord. 25% of cadre strength of district judge. 25% of the cadre strength of district judge. That means entry level. My lord may ask me, sir, who can be posted as PDJ, my lord? Can a district entry level can be posted as PDJ, my lord? No. Only super time scale officer will be posted as a PDJ, my lord. That is the, my lord, this government order in consultation with the High Court, Lord, fixes the percentage of, Lord, promotion to the post of district judge selection grade. Lord, 25% of the cadre strength of district judges who have completed not less than 5 years continuous service in the said cadre, entry level cadre, shall be eligible to be considered for promotion to the district judge selection grade. Kindly note it, Lord. The district judge entry level only 25% should be minus. High Court has not brought to the notice of Broad Court at all. Nowhere. My lord has to interpret now how to apply quota. My lord, 25% of the cadre strength of district judges. Yes. Yes, my lord. That's fine. Making my submission. Yes, my lord. Is 300, for example, 340. Accepting, not, I'm not admitting. Accepting that contention of the High Court, what is the fate? My lord has to decide now, because this is registered by Supreme Court. Afterwards, in consultation High Court, DPR passed this GO in concurrence with the Finance Department, because Finance Department implication is there, my lord. Finance means every GO shall be only with concurrent finance. I will come draw your lordship attention of the Karnataka business transaction, including district judge and High Court. Yes, my lord. super time selection grade, super time scale, both. Yes, my lord. Assuming for a moment temporary post is input, I'm not admitting. I'll come to that. Why it can't be? I will explain to your lordship. Not 25% is the lord selection grade from the district judge entry, my lord. Kindly further, my lord. My lord, kindly see further, page 40. 10% of the district judges, kindly note it, my lord. District judges who have completed, who have put service not less than 3 years continuous service of the selection grade. This is very important, Lord. High Court would have brought the notice of the before the single judge or before the. But I have not also brought the notice of the court. I fully admit it is my fault also. Lord, this fact was not brought to the notice of the division bench nor before the single judge. Nobody brought to the notice, including me, my lord. Since my lord has to decide whether dissenting view is correct or assenting view is correct, my lord has now decide which view is correct. My lord may say both view may not be correct, having regard to this, my lord, order. Having regard to this order. No, my lord, further, the quota is enhanced. Kindly take page 41. Though this is not, my lord, this is not applicable to my case because this will come into effect next page 41 on 2/2/24, my lord. This is not applicable, but it is my duty to bring your lordship's notice, my lord. Why? Because cadre strength is fixed. My lord, enhancing the quota of selection grade from 25 to 35. Page 41, my lord. My lord, got it? Kindly note it, my lord. 44.16. But Justice Shetty's commission report is accepted to enhance quota because district judge entry level will be stagnated otherwise. Therefore, my lord, from 25% to 35% selection grade from entry level. This has no application to case on hand, my lord. Kindly note that also, my lord, my submission. But I am making endeavor to your lordship, lord. This is the government order fixing the cadre strength also. Kindly note it, then page 42. In consultation with the High Court and Finance Department, for creation of additional post is also, my lord. Cadre strength is also, my lord. Kindly see, my lord, existing cadre strength, page, my lord, 42. 93 post as on, my lord, selection grade. Additional post 35%, 32 post. My lord, super time scale 15%, 5 posts, 37 posts fix ಮಾಡಿದ್ರು. Enhance ಮಾಡಿದ್ರು because proportion opportunity will not be there for district judge entry level ಅಂತ. Kindly note this has no application, but it is my duty to bring your lordship's notice that this quota is also not now altered because Supreme Court says so. Supreme Court says. Lord, Lord, page 44, Lord. But I was telling your lordship why Karnataka government allocation of business rules and transactions is applicable. I have produced a rule. This is a rule promulgated by the governor under Article 166(3) of the Constitution, which applies, my lord, allocation of business. It is whom allotted administration, High Court and district judges concerned. And you see, my lord, the rules called page 44, business of the state of Karnataka shall be transacted in the Secretary Department, specified in, my lord, in the schedule below, shall be classified, distributed between the department laid down. But these business allocation rules, transactions are mandatory. Mandatory, my lord. As far back, Constitution bench 73, Shamshi Singh case, my lord, Supreme Court held, my lord, business transaction allocation rules are, my lord, mandatory shall follow. I am making the attempt, my lord, subject matter of High Court is concerned, it is allocated to DPAR. Kindly note it, my lord, that page 45, Schedule 2, Department of Personal and Administrative Reforms. My lord, got it? Under the head G, kindly note it, my lord. Allocation of business is concerned, but why I am making my attempt? Because every post created, district judge, cadre strength, blood, with in consultation High Court blood, DPI has to blood pass the order. Either recruitment rules or blood executive order. Kindly see G, my lord. My lord got it, my lord, Department of Personal Administration Schedule 2. How business shall be transacted in government? Which department has to look after? Lord, various sets are there, Lord. A, B, C, my lord, D, my lord, come to G. G is, my lord, High Court. High Court and its administration, service matters relating to High Court, judges and district judges. Kindly note it. Only district judges and High Court judges. Not other service. Where I explained to your lordship 236(2). B. Judicial service means not the district judge. It's other cadre. But this is allocated to DPAR. Therefore, every creation, cadre strength notification with in consultation High Court shall be notified by DPAR in consultation with High Court. Consultation is very important. Without prior consultation, they cannot. My lord, then, my lord, kindly come to page 76. Not that DPR will control the High Court. No. DPR only look after expenditure of the High Court and the district judges. Nothing else. Nothing else. High Court control independence will not be. Will not. It's only business transacted among the department. One of the subject matter High Court is and district is concerned, DPR is the authority. Why I am making this submission? Because cadre strength notification, creation, everything shall be not promulgated by the DPR with prior consultation the High Court. If High Court is not consulted, they cannot pass executive order. They cannot. But now, page 76. This is, my lord, these rules are called, my lord have come across this rule probably, my lord has interpreted also. Karnataka government transaction of business rules. Why, my lord, I have cited, my lord, I produced this rule, my lord. Rule 17 is very important. creation of post and cadre strength. My lord will find directly page 79. My lord. And you see, my lord, how it is worded. No department shall, without previous consultation with the finance department, kindly note it, my lord, or as the case may be, the internal so and so, advisor so and so, deputy secretary to government concerned, in accordance with the government, consultation with financial advisor rules 82, authorized orders, my lord, kindly come to see. Relate to the number of grading and cadre of post, my lord. That is why, my lord, I am making my attempt to say that, endeavor to say that, my lord, 25% and 10% of, my lord, is my lord, meant for selection grade and super type respectively by the DPR with in consultation of the my lord, High Court, prior consult High Court. Relate number of grading, not it is a grade. District judge super times grade is a grade, it's a promotion. District judge selection grade is a promotion. Pay scale what is increased. Grading or cadre of post, kindly note it. Grading, cadre of post, the emoluments, kindly note emoluments and other condition of service. Therefore, my lord, no post can be created without prior consultation by High Court with the Lord in concurrence with the finance department by DPAR. Therefore, cadre strength notification is necessary, not merely creation. That is why it says you relate to the number of grading or cadre of post. Well, these are the enactment and rules holding the field in the state of Karnataka. But business transaction rule is also promulgated under Article 166 2 and 3, both allocation and business rules. Both are mandatorily followed. Law declared by Supreme Court also in Samshir Singh is the first constitutional judgment where business transaction rule is examined. That it is a mandate. Then, my lord, one full corporation, other things, my lord, consistently held, my lord, the business transaction rules, allocation rules of, my lord, they shall follow. They shall follow. They shall. But I need not explain now. 2783 to 19/2005. Quota is 1/3 for direct recruits, 2/3 for promotees. 19/2005 till 31/12, 2010. Quota is 50, 25 and 25 for direct recruits. From 1/1/2011 onwards, 65, 10 and 25 is a quota. Kindly note the date also. These are the brief facts to this court. How quota shall be worked out from time to time. I'm not admitting that post-based classification. Lord, these respondents have approached this court But initially questioning the final seniority list. Prepared in July 2016, my lord. 2016. But we are placed above the, below the appellants, my lord, private respondent appellants. Our prayer is in the writ petition is but volume 1. Writ petition, no, right? Only this. Not page 180. My lord, July 2016, my lord, the final seniority list was prepared, indicate retreat judge. And during the pendency of the writ petition, that was withdrawn, my lord, withdrawn. Prepared a fresh final list on 16/3/22. Annexure A and NR question. Initially, annexure A. My lord, kindly the prayer sought in the writ petition. My lord, B is quashed the seniority retreat judges. My lord, date is not given, my lord, number is not given, annexure A. C is, my lord, general prayer to prepare a, my lord, seniority list in accordance with law. Page 180, my lord, page 180, volume 1, probably. Now, D is not necessary. E is, my lord, amendment took place during the pendency of the, my lord, writ petition, where, my lord, respondents 4 to 12 are placed below these respondents. Therefore, my lord, we filed a memo to delete respondent 4 to 12. Lord, that is quashing that 16/3/22 list. Consequently, assign seniority above the respondents 13 to 82, leaving 4 to 12. Kindly see page 181. According to them, 24, date is not given. Kindly see annexure A. That is also there. Date is not given, unnumbered. My lord. Annexure A, page 184, my lord. Kindly see, my lord, no date. But they say, my lord, they have given the date as, my lord, 24/7/2014. My lord, annexure A is undated, July 2016. Date illa 16. But kindly see the, is it a seniority list or list of, not civil list? But how, not seniority can commence from serial number 38 onwards? But seniority shall be prepared according to Rule 10 of, not Karnataka government seniority rules. Kindly note it, Lord. The basic, Lord, rule is Rule 10, which is applicable to district judge, because 83 rules, 2011 rules, 11(2) says all rules framed under under any law or 309 is applicable. Rule 10, Lord, mandates, Lord, how Karnataka KCS, Karnataka government seniority rules, Karnataka government in bracket seniority rules 1957. Quota, sir, if you have service manual. ಇಲ್ಲ ಮೆಮೊ seniority rules ಹಾಕಿಲ್ಲ. ಎಲ್ಲೋ ಹಾಕಿದ್ದು ಸೀನಿಯಾರಿಟಿ ರೂಲ್ಸ್ ಹಾಕಿ ಎನ್ಯಾಕ್ಟ್ಮೆಂಟ್ ಏನಿದೆಯೋ ಪರ್ಟೈನ್ ಅಷ್ಟೇ ಹಾಕಿದ್ದು. ಅದರ್ ರೂಲ್ಸ್ ಅದು ಬಂದಾಗ ನಾ ಹಾಕಿಲ್ಲ. But other rules are applicable. Rule 10, my lord, mandates, my lord, how it should be prepared. There shall be prepared every year for each cadre of service, class of post, a seniority list consisting of names of all officers born on the said cadre. All, whether retired or not, their name must find place. Basic rule is all officers' names shall find place. No, not at all. But not we, for a lighter way, not we direct other department to do it. But I am fairly making my submission, barely making my submission. But we failed in our duty. Our house is not in order. But the what rule says consisting of all officers born on the said cadre, classes of post arranged in the order of seniority in accordance with the provisions of these rules. The seniority shall be prepared by concerned appointing authority. Whether, my lord, annexure A or N is conformity with rule 10. Basic rule, let alone quota. But kindly come to, court has to find out, these are the promotees, these are the appointed to competitive exam, these are direct recruits. Can it be? The counsel for the private respondents have not even contested the writ petition, nor filed reply statement, but they are arguing before this court on facts. But I can understand High Court will argue, yes, High Court has filed reply statement. I am not saying that. Page 184, kindly see. Then I come to annexure N. Whether basic rule of seniority, rule 10, is not followed. But why? Not only 2003 should be, my lord. But there must be 38, 2003 onwards. There are no, lord, appointment take the 83 rules, my lord. There are number of appointments took place after 27/8/83. My lord, series number 38 onwards, my lord, kindly see no classification of post, my lord, whether promotive quota is this much, my lord, direct recruitment quota is this much. There must be statement of facts, my lord, which they have produced, my lord, in the earlier litigation. In the earlier litigation, High Court has produced, which I have produced annexure P in the writ petition. Statement of, my lord, classification of vacancy and Thakpara. But they admit, my lord, 83 onwards, 63 for 2/3, 1/3 quota would apply. They admit. But in page 184, my lord, very similar, only names of the civil list, nothing else. Nothing else. On the face, I am making my submission, Lord. This seniority list cannot test the, Lord. Now only change is in N, except not placing the respondent, Lord, 4 to 12, because they are promoted in the month of March. We are appointed prior to March 2016. We are appointed in 1/2/2016. They were promoted in 4/3/2016. They are placed below us. Only change is not annexure N, my lord. Kindly take second, the final seniority list published during the pendency. My lord, page 548. But page 548 is volume 3. Volume 3, my lord. My lord, seniority list subject to correction, my page nation is correct. No? No, sorry, page nation is not correct. Page nation is not correct. Yes, not page 483. If I'm correct. No?
Annexure K, Annexure N 584.
584, correct. 584. 584.
ಒಂದು ನಿಮಿಷ
But 548 blood, if I'm correct, blood subject to. But 548 blood got it. Volume blood 3. Blood no change in serial number. Blood. Only remark column changes there. Kindly compare annexure A and N. Except change of remarks. Blood no change. And placing the respondent 4 to 12 below this blood private respondent. That is all the change in this list. This is also blood nothing short of civil list. It is a civil list. It is not a seniority list. But where is the blood? My lord asked me in earlier occasion, High Court, Lord, division bench, Lord, before the division bench. Yes, Lord. No doubt, Lord.
One change is that.
Yes, Lord. 4 to 12 placed. That is the change, Lord. I am making my submission. Because they were promoted in the month of March. First day. Because they are promoted later to our recruitment, they are placed. That is the change.
And before the learned single judge, they have been deleted.
Therefore, we have deleted their names, 4 to 12.
Before
Only
the-
prayer is restricted to 30 into 82. But kindly note it that.
Initially, when petition was filed,
4 to 12. Initially, they were parties. They were parties.
when Annexure A was in force,
When annexure A was in force, they were parties. When annexure N was not amended, we find a memo, delete them 4 to 12. We are seeking receipt of pay 30 into 82
because in Annexure N they have been
because they are placed above us.
placed below us.
They are placed above us, 13 to 82. My lord asked me, annexure P, page 6055, my lord, the statement of my lord post annexure P, volume 3, page 655, was the document produced by the High Court in the earlier litigation. Which they also say yes. Page 655. My lord, we kindly see 55, 655. If I'm subject to correction, my lord, High Court admitted 62 2/3 quota. Kindly note the date also. 1/1/2003, according to them. Admittedly, my lord, quota applies from 83 onwards.
This is an argument of private respondent.
But it is the first time the argument of the respondents, appellants, private respondents. Right? There is no quota till 2001-9-2005. Can it be, brother, accepted? This argument was addressed by the learned senior counsel before the division bench. I'll draw your lordship's attention. Division bench also brought the learned senior counsel said 83 quota would apply from 83 onwards. accepting the said contention, rejecting the contention of the very learned senior counsel, court held, my lord, para 60 of the division bench judgment. Para 19, not kindly noted, the learned senior counsel raised that question. Quota is not applicable from 83 rules at all. Quota will be operated only from 1/9/2005. That is the contention raised. But judgment is placed, Lord. I will draw your lordship's attention. Not much about it. Yes, para 19. Lord, may kindly see the list of citation, page 61, Lord, which court officer has already given citation given by us. Lord? Yes, Lord. If your lordship refers to the volume. Page 61, Lord.
ನಾವು ಕೊಟ್ಟಿರೋದು ಅದೇ
Page 61.
ಹ್ಮ್
19.
ಸರಿ page 72
Page 72, my lord. Page 72, my lord. Division bench.
in the list of citation
In the list of citation given by me, my lord. Given by the
ಇಲ್ಲ ಇಲ್ಲ ಸರಿ ಇದೆ ತಗೊಳ್ಳೋದು ಸರಿ ಇದೆ
the learned senior counsel so and so appearing for the promotees contended that 93 FTC were established under the various orders of the state government for dispose of long pending cases. Only 2 notification dated so and so. The word temporarily phrase subject to reversion at any time were mentioned. In 2 notification 1511 so and so, under which 61 judges were promoted, opposite expression were absent. In fact, appointments of the FTCs were made following procedure envisaged under the 83 rules of obtaining the orders from the Excellency Governor. Promotion, though termed as ad hoc appointments, were officiating basis. Promotees were given pay scale, other benefits applicable to district judges. All of them have performed their duties at district without reversion. Some of them retired while serving as FTC judges under 2009 notification. Promotion were regularized. It would relate to the initial promotion made year 2003-2004. The promotees were serving FTC judges. Petitioners were directly recruited as district judges by notification dated 13/2008. As also contained that 83 rules, no quota was provided. Kindly note it. Not got it? The argument. No, under 83 rules, no quota was provided. For the first time, under 2004 rules, quota in the matter of recruitment of district judge was stipulated. Kindly note this argument. Specific plea was raised. My lord, Pyara, my lord, rejected the argument, my lord. The court holds, my lord. 2/3, 1/3 quota applies from under 83 rules. My lord, para 60 finding, quota. Para 60 is finding. Therefore, my lord got it. Para page 90, para 60.
58, para 58 and 60. ಅವ್ರದ್ದೇ ಕಂಟೆನ್ಷನ್ ಆಗುತ್ತೆ.
Para 58 ಅಲ್ಲಿ contention of the my lord learned senior counsel again referred. I did not read it. My lord, finding is para 60. Para 60 finding.
60.
Finding is, my lord, kindly see what is the finding. Under 83 rules, 33.33 total post was to filled up by way of direct recruitment. 66.67 total post to be filled up by way of promotion. Statement showing particular cadre strength. Regular district judge. Number of posts filled. Number of posts reserved for promotees. Under 2/3 cadre strength. Number of district judge promoted from the cadre civil judge seniority produce annexure R1. That is annexure P. Annexure R1 is P. Now produce. Lord, this finding, Lord, is very clear. Still, my lord, the appellant in the other case, my lord, argued 83 quota has doesn't apply, no quota, only 2005 quota. But we must be fair to the court. Whether we win or will not, we lose it case, immaterial. Court has to lay down the law, either one or other way. Then, my lord, para 61, quotes the 2004 rules, my lord. Kindly note it.
66.
Page 61, my lord, again 2004. Seniority.
Annexure R1 referred in P.
Annexure P is annexure R1, my lord. Kindly note it, that also. It is not disputed, my lord. Earlier R1.
Referred in para 60.
Referred in para 60, my lord. My lord, now I make it very clear that 28/7/83 till 31/12/2010, 2/3, 1/3 direct equities shall be classified based on the posts from blood 19/2005 till blood 30/1/12/2010, 50, 25 would be applicable. But now, but you have to point out this now. Supreme Court 94. But I make it very clear. Lord, 2783 to till 2005, this is the quota. 2005 to Lord, 31/12/2010, 50, 25, 25. 1/11/2011, 1/1/2011 onwards, Lord, 65, 10 and 25. This is Lord, from the expression on the rules, Lord, this quota is. But the citing of Supreme Court Apex Court Judgment 94 is misplaced. I'll show your lordship on the face. Kindly take volume 1 probably cited by my learned friend. 94. Ashok Kumar. But I will come there. Why should Yes, subject to my lord. Yes, tell me. Yes, 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 my lord. Lord, it is observed, my lord. 83 rules, 1/3, 2/3 quota is there. That is observation is there. No, my lord, no finding. No finding. Excess quota, no finding. No finding. Here also no finding by the learned single judge. Nor by lord the dissenting judgment. Quota is violated. What is the violation? We do not know. They have to work out. But can this court can work out before the court? Can the respondent appellants who have not filed their objection can work out? Say no, 34 post adjusted like this. Can it be? It is the duty of the registry to work out. Not the duty of the Lord, the full bench or Lord the learned single judge. No, my lord. Government does not file. Lord, why I am making this clear? Government does not file. High Court has filed objection. High Court has taken a specific stand that date of promotion, date of recruitment is taken into consideration while preparing seniority list. I will show my lord in the reply statement filed by the High Court. Then I will come. No, my lord. Doubt is created. Apex Court in 94, Lord Ashok Kumar's case, interpreting the Lord Tamil Nadu Judicial Service, held no quota for direct recruitment because 10 posts was meant for each recruitment, direct recruitment. No percentage is mentioned. Yes, Lord? Yes, Lord. My lord, quota is concerned, my lord. It is there.
ನಾವು plead ಮಾಡಿದ್ದ excess ಸರಿಗಳನ್ನು ಮಾಡಿದ್ದ. Page 142.
Page 142, my lord, volume 142, petition.
Volume 1.
Volume 1. My lord,
ಅದೇ ಸರಿ.
Page 172, my lord, we have made a passive pleadings. Number of posts, how it should be worked out. We have taken specific plea. Page 172, para 5.6, volume 1. Volume 1, writ appeal 404, sorry, my lord, 1006, High Court writ appeal, my lord. Page 172, 2, para 5.6. Two. 5.6. Learned Judge has given a specific finding also. Last paragraph of the order. I have not taken post-based, my lord. Though the division bench of this court says, my lord, vacancy based, my lord. Not the division bench of this court which I cited, my lord, says vacancy. Vadami would be applicable. Kindly note it. To that extent, it may be, my lord, according to me, my lord, recruitment rule itself says post only, not vacancy based. High Court says we are bound by the division bench judgment. But 5.6 particularly have pleaded the quota, 65%, then 25%, my lord. But quota is pleaded. Absolutely no pleadings are there. And Randy Singh also refers it and says, my lord, quota is not worked out. And the dissenting judgment of the learned judge also says, agreeing with that, my lord, quota is not worked. But kindly see annexure A, remarks column increase in cadre strength. Annexure N, remarks column, all those things are removed. Annexure N, A shows this is the cadre strength increased. Annexure N, no remarks. That is why learned thing I say, increase in cadre strength, you are not at all worked out the quota. Not got 5.6. Particularly, I have created the what is the quota available at that time, not for anything else. Yes. Yes, Lord. Yes, Lord. Yes, Lord. Yes, Lord. Yes, Lord. Yes, Lord. Yes. Yes, Lord. Yes, Lord. A came to be published. Then, Lord, we made representation. Then, Lord, full court, Lord, has taken a decision to withdraw that risk. Yes, Lord. Particulars are not available. We are not pleaded then. Because we are not pleaded. When promotion. But the question before your lordship is, your lordship is, two questions of law. Because that promotion has nothing to do with us. If quota is worked out, right? Either pushing up, pushing down, principle. Yes, Lord. My Lord, court said there is a breach of quota. You redo it. Yes, Lord. No finding. That's finding. Then, my Lord, court need not, my Lord, say you redo it. Yes, Lord.
Page 215 on annexure.
One minute. But I will read the para 84, my Lord. Direction issued by the High Court, my Lord, the division bench. Yes, my Lord. Finding an argument.
They refer the previous order. At the outset,
But at the outset, undisputed facts may be stated, petitions were appointed.
Shadina not
Are they 52, my lord? It is a fact. Yes. Yes, my lord. I'll read. I'll read. Uh, Direct equity at district judges notification at 13/2/2008. They took charge on 25/2/2008. Promotee judges were appointed or promoted. Temporarily ad hoc judges prior to the date notification 15/2/2003, 19/3/2003, 15/11/2003, 23/2004. 8 civil judges senior division were promoted on ad hoc basis to officiate district judges with immediate effect to man the FTC subject to reversion at any time. Expression to man FTC in the aforesaid notification were deleted by corrigendum dated 21/4/2003. It is not dispute that directly recruited district judges were appointed within their quota 25%. Similarly, promotee judges were promoted, appointed within their quota 50%, 25% filled up by promotion on the basis of the seniority come merit through departmental competitive examination. This finding is, yes, ma'am. It is also not in dispute pursuant to the recommendation of the 11th Finance Commission, establishment of FTC, ad hoc promotion to the post of district judge were made. 24. As per Rule 2004, thus quota rule has been maintained. There is no transgression of the quota in the instant case. Kindly, it is a finding of division bench, no doubt, but division bench did not take notice of the cadre strength of super time scale and, my lord, selection grade. It is unnoticed by the division bench. This finding is without any basis. Where is the, my lord, it is brought to the notice of the High Court. No, my lord, that's why I have made my submission, made it very clear, Lord, I have not brought to the notice of a single judge, nor the division bench. I am bringing your lordship notice because this bench is constituted specifically whether dissenting view is correct or assenting view is correct. I must not bring to your lordship's notice whether to apply or not is left to the court. Yes, Lord. Yes, Lord. Yes. But, yes. Yes. But I make it very clear because it is a failure on my part to bring the notice of the court that not 25-15% is brought district judge cadre shall be brought meant for them. This is not brought to the notice of the Lord, none. My Lord has to examine now. My Lord is laying down the law. Otherwise, my Lord is right. And I am not brought. And I, beginning itself, I told, while reading the government order itself, I admit. Yes.
paragraph 5.6.
5.6, my Lord. 5.6, page 172.
And how that is rendered by the legislature.
This has been accepted by the single judge.
This has been accepted by one single judge. Yes.
Even know that.
But may I read this, my Lord? This paragraph 5.6, then come to one single judge.
Page 170.
Page 172. Lord, I assumed that division bench judgment vacancy based, Lord, classification. Kindly note this, Lord. Reading, entire reading is vacancy based, not post based. Yes.
We are talking 10% or 25%.
Yes, ma'am.
That refers to the strength of the case. It cannot be. Suppose there are 10 vacancies.
Yes, ma'am.
You can't start applying the ratio for every vacancy.
No, I'm not saying.
No, I'm saying. So what you are saying is
Yes,
that
Lord.
it should be the entire cadre.
Yes, my Lord. That is what 5.6 says so. 5.6 particularly pleaded that this is the cadre strength at that time, this is the allocation. Kindly note it. Pursuant to the improved final seniority would reveal that 139 officers said to have been accommodated, adjusted in respect of post as a result of increase in cadre strength. Annexure A shows increasing in cadre strength. Annexure N, Lord, remarks column, that is deleted. Admittedly, according to the notification they produced before the division bench, increase in cadre, increase of the cadre strength, district judge. Officers at serial number 38 to so and so, the said posts arose as a result of increase in the cadre strength have been earmarked for quota prescribed under the rules for direct recruitment promotees by way of competitive examination. It is to be mentioned here that in respect of number of promotees, there is no mention the date on which cadre strength is increased. However, even assuming there is an increase in cadre strength by 139 posts, only 90 posts are available under 65 promotion quota for the post of the cadre district judge and have increased. However, the final seniority list would reveal 114 posts are promoted against 65% quota, though only 90 posts have been earmarked for promotees. Then, my lord, 114 promotees are adjusted against vacancies under so and so, increase in cadre strength shown at serial number 38 to so and so. The vacancies have not been classified among 3 sources of recruitment. Post of district judge after making block period commencing from date 1983 rules. Thus, respondent 13 who were promoted in next 65% quota meant for promote cannot be given seniority over and above. How it is dealt by the learned single judge? What is the reply of the High Court? Madam, kindly note it. In the reply, they admit that seniority list is prepared based on the date of promotion, date of direct recruitment. Kindly now take the reply and then I will go to finding of the learned single judge. Then when I come to sir rejoined. To meet that point, when I find a rejoinder, High Court files rejoinder. But High Court never produced the cadre strength creation of post notification before the learned single judge. Those notifications are produced before the division bench. 588. But 588 volume 3. Volume 3, page 588.
Statement of objection.
Statement of objection, yes. Page, my lord.
588.
588 commences, my lord. But 611 is the admitted fact by the High Court. 611. Not kindly see page 611. Not got it? Not the commencing sentence commences of the final seniority list. Not got it? Is prepared according to the date of entry of service. Kindly note it. Date of promotion as district judges. This is the reply statement filed by the High Court. The details of the mode of promotions are mentioned in the final seniority list, hence contentious petition liable to be rejected. But I showed your lordship final seniority list. Where is the statement of classification of post? Nothing is. That is why it is called a civil list, according to me. No, my lord. High Court says, my lord,
Page 614.
page 614, my lord.
Admit what the 314 is the catastrophe.
My lord, kindly see, my lord, what I have stated 5.6 is correct or not. 614, my lord.
Page 6.
Page 614. My lord, date further as stated supra, my lord, got it. Page 614. Last, my lord,
7 line.
7 line from the bottom. Kindly see. As on the date of appointment 21/1/2016, my lord, our appointment of the petitioners. Sanction strength litigious 314. Not what I have stated 5.6 is correct, not they admit. Out of which 204 were promoted under 65% quota category. However, as on the date of their only 93 officers working under the cadre so and so,
193.
193 said category post. Therefore, no promotions have been made in excess. But according to me, my lord, in one High Court says date of appointment, date of promotion is taken into consideration. From the reply statement, date of promotion is the date of quota. Date of recruitment is date of quota. But it must be reflected in the seniority list. Statement of post or vacancies. My lord has to revisit the division bench now because of the Supreme Court judgment and recruitment rules and the later government order which has come into effect from 1796. But undisputed fact quoted by the division bench, not in the light of the government order which I have produced, my lord, in the list of enactments. No. But government order prescribing the quota for super time scale 83 rule itself says, Lord, super time scale is there. Where is the working out quota? No. Nowhere. Even division bench doesn't note it. Whether that Lord 83 rules super time scale is there or not. No. Lord, government order as per Supreme Court judgment, Lord, came into effect, Lord, on 22/4/2006, which I have produced. But can it be ignored now before by this court? When it is brought to the notice of the court, Lord, it is not brought to the notice of the court, correct? But we are before this court revisiting the judgment. According to law, this is the quota meant for broad DT selection grade and super time scale. It shall be deducted from the total number of posts, excluding the temporary post. My lord has to decide now quota. Though it is not brought to the notice of the Lord under single judge or to the division bench, either by any of the parties. But the pure question of law, estoppel against law will never arise, my lord. According to me, estoppel fact, yes. If the law is this, and it is brought to the notice of the Lord, this court has to interpret the quota according to the law amended from time to time. That is, Lord, law is declared by apex court. Can it be ignored while interpreting the Lord quota? That too in the All India Judge's case. We are bound by law declared by Supreme Court under Article 141, every authority. no estoppel will arise. Merely it is not brought to the notice of the division bench or single judge by any of the parties. Therefore, my submission to your lordship, my lord has to interpret the government order dated, my lord, 20 to 4 2006, quota in the judiciary entry level, super time, selection grade and super time scale, which shall be deducted in the total number of posts excluding temporary post. Why temporary post cannot be excluded? I will come. Single judge. Single judge. Single judge. Single judge. There. Para 34 of the learned single judge will not give a finding. Except redo it. Learned single judge never said where they should be placed. It's the duty of the registry to work out the quota. Paragraph 34. 32 and 34.
Finding fast track judges ಬಗ್ಗೆ ಬರುತ್ತಾ?
Para 30 deals with the fast track judges. Para 34, 33 and 34 deals with the quota, how it should be worked out.
Page 138.
Page 138, para 33 and 34 of the learned single judge. Learned single judge never said what you have to do. You will do it. Working out quota. Page 138, para 33.
Relying upon Yamini.
Relying upon Yamini. Not order of the division bench finding that fast track courts are entitled seniority is contrary to Supreme Court Apex Court judgment. Therefore, that seniority is withdrawn in 2016. They are anti-matter. We are not parties, but we can take a contention. We are not bound by the judgment of the division bench because we are not parties. What is the correct law enunciated by Supreme Court in the matter of appointment of fast track judges? Para 33, page 138. Volume 1. Applying the aforementioned ratio to the facts on record, judicial officer promoted ad hoc basis as additional district judge, their seniority is considered only from the date they are appointed substantively against the vacant post, not from the initial appointment ad hoc district judges. This finding is based on the Apex Court judgment. Apex Court protected their interest also. I did not make them parties ad hoc fast track judges because Supreme Court said they are entitled senior pay, protection, pension, everything. Kindly note it. The argument of the other side appellant is they are not made as a party. There is no pleading before the single judge because they are not filed reply. But I have to answer this question to your lordship. Even assuming for a moment they are not made a party, that is what dissenting judgment says. Even they are not parties, no, their service condition will never be affected because their pay, not pension, is protected. Under the umbrella of apex court judgment, they are entitled to all protection except quota. Para 33, applying the aforementioned mentioned ratio to the facts on record, judicial officers (33 and 34) blood is very clear. Quota is not work 34. The question before your lordship is not whether division bench judgment undisputed facts without examining the quota as per the government order dated 2002, because it is not brought to the notice. My lord has to lay down the law. It is not binding on your lordship. That seniority list is also spent its force because they have they have withdrawn that list. And we are not parties. We are certainly agitated the matter before this court. It is not question of fact, Lord, question of law. 25 plus 10% of the district level shall be deducted. This court cannot ignore it. Therefore, my submission to your lordship is, my lord, question number 1, whether quota is not breached in view of the recruitment rules and other enactments as per the apex court judgment passed in 2002 and 2010. Question number 1. Question number 2, whether finding of the learned division bench as far as fast track judges is concerned, though there is no finding, redo it. My lord has to answer it. In view of the apex court judgment, my lord, change of law, my lord, we are all bound by it. No way. The division bench judgment says the seniority rule is applicable, my lord. It is implied, my lord. I showed your lord's rule 11. Rule 11 of the my lord, Karnataka Judicial Service Rules, my lord, 2011 or 2005 or 83. All recruitment rules, all other rules. No other question will required to be regarded. Yes, ma'am. Yes, ma'am. Yes. Yes. Now, Rota is concerned. 2002 Supreme Court says Sabharwala case is bound to follow before 31/3/2003. I will come to that. Supreme Court has fixed a deadline. But there's no discussion. There's no. That's what I'm making my submission. Huh. Yes.
I have arrived at a conclusion that reckoning the seniority of the promoted from an affiliate date would amount to violation of principle.
Yes, ma'am.
Yes. There is a discussion for this finding and on a factual aspect.
On facts, ma'am.
By the learned single judge. Where are the facts? How this conclusion is arrived at? Where is the discussion?
Yes.
So there is a finding that it has exceeded. So where is the discretion to come to such finding? We find it is
In the light of the Lord, the new enactment brought before your Lordship, that also shall be taken into consideration. And otherwise also I will come. That I will come.
and where is the discretion and where is the material
Yes.
for the learned judge to come to such conclusion? That it is excess of
Point for competition.
ಒಂದೇ ಒಂದ್ ಕಡೆ ಸಣ್ಣ ಅಬ್ಸರ್ವೇಷನ್ ಮಾಡ್ತಾರೆ.
Submission.
ಇದು but not in so many words.
Some reference is there, Lord. I'll show. I point out. Lord, page 93, para 20. Point out for left.
ಇಲ್ಲ
This full.
ಇದು ಹಳೆ judgment.
High judgment.
What we propose
Yes.
from Monday onwards, next Monday onwards,
Yes, Lord.
we propose that 1 hour every day. Monday, if everything otherwise is okay,
Yes, Lord.
administratively possible, 1 hour every day, between 3:30 onwards, we can start and continue what we have in mind.
ಇದು ಒಂದು ಸೆಷನ್ ಕೊಟ್ರೆ ನಮ್ಮ
Monday post,
One full session I require. That's all. I don't want to not take more time.
suppose there will be some queries,
Yes, Lord.
we have to ask.
Certainly, I am answerable.
So what we do,
Yes.
we start from Monday.
Yes.
Post lunch.
Yes.
Roughly 1 hour every day, we can continue.
Yes. In the